notice procedures. Off the record, there are many interested parties here. I indicated that Attorney Pellerin would put her motion on the record, and if any party who is here in the Zoom call wish to speak to the motion or be heard before I make my decision, I would allow that to occur by the party unmuting, stating their name and their interest and what they wish to say. So with that, Attorney Pellerin, you may proceed.
Thank you, Your Honor. And I would like to note for the record that Receiver Rebecca DeMarb is also appearing via Zoom. So, Your Honor, this motion is for an order implementing certain notice procedures. There are over 4,600 notice parties in this case. These include former customers of New Moxie Solar, its predecessor, Moxie Solar LLC, and then also Moxie Solar Inc. We cast a wide net in terms of noticing folks that might have a claim against the entity, the debtor, in this case. Many of the folks that were noticed might they might not have a claim. They might not wish to participate in the receivership. But as notice is important. So that's why we opted to notice all 4,600 plus entities and people. Our motion aims to limit any future notice that would be required, to limit it to both the secured creditor in the case, debtor's counsel, and any party that has a specific interest in the subject matter of any future pleading, and any party that files a notice of appearance and requests additional notice formally with the court. That's, as I indicated, there are over 4,600 notice parties, and serving all of those folks on each motion or pleading that has to be filed with the court logistically will be difficult, and it will be very expensive. The postage alone was in excess of $3,000 just to notice the folks of the receivership. Furthermore, if a party is interested or wants to receive notice, they have a way or means of doing that, and that's by filing a formal notice of appearance with the court and requesting to receive that notice. It would also assist when the court issues any orders or notices or anything of that nature. It would also limit any noticing that the court would have to do as well. We think overall it's going to be a much more efficient means to move forward.
Okay. Anyone objecting to the court ordering the notice procedures as outlined by Attorney Pellerin? She's indicated that notice be limited to secured creditors, debtors counsel, parties with a specific interest, and parties who filed a notice of appearance in this matter. Does anyone wish to speak to that request?
I would ask.
I said, wait, Mike Donahue. Mr. Donahue, you've asked to speak. What is your interest in this case?
I have I requested a solar system be manufactured for me or installed for me by Moxie Solar. They took $30,000 of mine, and they've basically done nothing.
Okay. And so are you objecting? Well, I'm asking, are you objecting to the procedure for notice that Attorney Pellerin has outlined?
I'm not directly objecting. I'm asking for one amendment to it. I would ask that one time that they send out appropriate information to all people on the list, stating how they can be included in future communications.
I have to agree with him.
May I respond, Your Honor?
Yes, you may.
A party may formally appear in the case and request notice. That's how he or she would receive notice going forward.
Okay.
I believe there is a procedure set forth in the order.
So it sounds like that's already part of the order, Mr. Donahue. Reverend Rick Risley, you wanted to say something?
Yes, good morning. I'm Rick Risley. We had a solar system installed on our farm a little over a year ago that was never completed. It was not a financial issue. The system is up and running, more than a maintenance issue. I would like to be included in all notification. I have not filed a lawsuit at this point because we had just started to gather information at the end of the year. And then, of course, we found out that Moxie went out of business. So we've been waiting to see what happens.
Okay, well, again, I think Attorney Pellerin has spoken to that,
Okay, thank you.
procedure that you can follow to be included in future notices. Anyone else wish to speak? Loretta, what is your last name, Loretta?
Loretta Sylvia. I am interested in getting information, continuing information, and I know Attorney Pellerin said there is such a formal, I wrote it down so I wouldn't forget what to say, but I obviously lost that piece of paper as I was looking. But the thing is, she said there's a formal way to do this, but we don't know how. If I have received that information, I am not aware of the process. As I read the change to the email that changed the Zoom address, it was at the very bottom of Miss Rosie, I don't remember her last name, her email saying that you can file for this change. So the question is, we really need some clear, concise instructions. It's not a matter of knowing that we have to fill out this one form. It's knowing how do we go about filling out this one form.
Attorney Pellerin, you wish to speak to that?
Sure, Your Honor. First, there is no form for filing a formal notice of appearance. That's a document that's filed with the court. As it relates to filling out, I don't know if Ms. Silva is referring to the proof of claim form, but that's not something that my office or the receiver can assist her with. She'll need to contact her own attorney to fill out the proof of claim. Although I would also note that another option, if it might be easier for the parties, instead of filing a formal notice of appearance, if they could contact me in writing to be added to a service list, we can maintain a list that way, a service list that way as well. And we could update that with the court on a weekly basis. I think that should be sufficient.
Okay, well, why don't we add that to the order that the parties can contact your office to be added? And why don't you, for the record, everyone take a moment and grab a pen and paper if you're interested, or a computer, and write down, we're going to give you the information on where to send to Attorney Pellerin if you wish to be included. And that will be incumbent upon all of you to let her know if you want to be. She's not going to be contacting you individually. So Attorney Pellerin, what is the address they should send their request to be notified?
It is, Your Honor, 33 East Main Street, Suite 500, in Madison, Wisconsin. And the zip code is 53703. I can note further that that is my office's address, and that is located at the bottom, at the signature line of the motion to implement these procedures, these noticing procedures.
Would you also accept an email filing?
Yes, Your Honor.
And what email can they email you if they wish to do it that way?
N Pellerin, so that's N, then P as in Paul, ELLERIN at murphydesmond.com. That is also in the signature line of the motion.
Yeah. May I speak again?
Sure.
I think what I know that what I'm seeking is not to attend your court every time, but to get knowledge of what is happening in the court. Is there a way that instead of each person having to sign in and come to court, everybody, hello to everybody, sorry, I saw that something distracted me. Is there like a central location where they could just post what is happening in the court, or send us an email of a summary just something so that you don't have to you don't have to appear in court every time.
Well, I don't think I can place that burden on the party to notify people of what's happening. I think that if you want to participate, you participate. If you don't, you don't.
Thank you. That's fine. Thank you.
Garrow M, did you want to say something?
Yeah. I think at this point I'm. Oh, sorry.
Sorry, I need an identify. You have to say your name before you speak.
Yeah, this is Garrow. It's Mike Garrow. And no, I unmuted because I was going to ask a question, but basically I think I can email in and just express my continued interest. So that's all I need. Thanks.
Yeah, I don't need any more comments on continued interest or any of that. I just need to know if there is an objection to the procedure that has been set forth by Attorney Pellerin, and that we've made the addendum to that you can send her a letter or email her if you want to participate in future proceedings. Any objection to that?
Michael Majeski has a question or objection.
Okay.
And that is, I don't understand the jurisdiction of this motion or of this proceeding over out-of-state people, over contracts with a conflict of law clause that said Iowa. How is this court and Attorney Pellerin moving this forward? I mean, if I need to submit to jurisdiction, that's fine, but I don't quite understand how there is the court's authority out of state on this.
Well, Mr. Majeski, I cannot give legal advice. I'm the judge sitting here. There hasn't been any formal objection to this proceeding, so I'm not going to comment on any of the questions that you've asked. Those are legal questions. I would suggest you contact a lawyer if you wish to pursue that.
So that does not count as an objection, Your Honor, what I just said. That there's no jurisdiction. I'm raising that as an objection.
Your objection is noted. What I'm saying is I can't provide you. You asked a question as to how, and I'm telling you I cannot provide legal advice, but your objection is noted. All right. Attorney Pellerin, I'm going to grant your request for the implementing certain notice procedures. I'd like you to file an order with the addition of what we discussed on the record, which is that the parties can contact you by letter or by email if they wish to be included in further proceedings, in addition to the other parties that you've identified as being included in this notice.
I have a question, if I could.
Okay, this is your Joseph Obleton.
Joseph Obleton.
O-B-L-E-T-O-N. Mr. Obleton, what's your question?
My question is, my solar has been installed, but I'm concerned now about the maintenance agreement that goes with it.
Okay, I can't help you with that. This is the court proceeding on the receivership. So I mean, if you have questions about that, that's not anything this court proceeding or that I can answer on the record in a court proceeding.
Well, the other part of it is then I should write of that concern to the attorney and have it included.
If you can protect your rights, sir, in whatever way you wish, I would suggest you contact a lawyer if you have questions about the process. I cannot give legal advice as the judge.
I understand that.
Okay. Attorney Pellerin, is there anything else we need to do today?
Not with respect to the motion, Your Honor.
Okay. Any further scheduling you wish to talk about at this point where we can go off the record and do that?
I do not believe so, Your Honor.
All right. Anything else for the record today, Attorney Pellerin?
No, Your Honor.
All right. If you send that order in, I will sign it so that it becomes part of the formal record. When you're ready to schedule further matters, please let us know. If we don't hear from you in 90 days, I'll likely set a status conference and keep the people in the loop who wish to be in the loop. Okay?
Very good. Thank you, Your Honor.
Thank you. We're adjourned.